Welcome. You're watching Head to Head. I'm Antonina Antosha with UATV. On October 21st this year, the Code on Bankruptcy Procedures adopted by Ukraine's parliament came into effect. The new code is addressing the deficiencies of existing bankruptcy procedure. To discuss this, we're joined in the studio today by Arne Engels, international expert of the EU Project Pravo-Justice, attorney at law, specialist in restructuring and insolvency cases from Germany. Hello and thank you for joining us.
Thanks for inviting me.
So if there is a new code that has been adopted, there's obviously an old code. So what's new about the new code comparing to the old one?
Comparing to the old one, there are slightly differences that have been made within. So you have to sell every asset within bankruptcy proceedings on a e-based platform only. You're able to have personal insolvencies in Ukraine, which is very new. And there is a new organization for insolvency administrators that was created yesterday, also published in the code.
So how's it going to function now? What's new for those institutions who decide to file for bankruptcy?
In general, nothing new. It's just the new code just adopted to the international rules and tried to be more obvious for international companies to understand as well.
So the new code reviews the role and competences of bankruptcy trustees.
Yeah, of
right?
course.
Reviews the role. What's going to change for the trustees?
Well, the trustees is changing a lot because they have to adopt to new proceedings and they have to adopt how to represent the debtor and what they can do for a debtor within the proceedings. So that's quite a big issue. Also, they have to, within the new structure, they are not reliable anymore on the Ministry of Justice, but they are more or less reliable to the creditors and the new founded SRO.
Is it gonna make the whole procedure of filing for bankruptcy longer or more complicated? You cannot file for bankruptcy without having a trustee, right?
No, you get the trustee later. So
Okay.
first of all, you're saying that you're bankrupt. Bankrupt means that you're not able to pay your debts.
Right.
So that's a very easy understanding.
The explanation, right?
Yeah, very easy explanation. It's much more complicated, but to say if you are not able to fulfill your debts, you have to file for insolvency. Once you are filed and there is a special list of documents you have to present to the court, and the court decides, okay, you are insolvent. You are getting a bankruptcy trustee who is doing the work later on and who's representing the company.
Appointed for you by state?
Appointed by the court.
Okay.
So the court chooses.
What happens next?
The court chooses what's happening, and then there is different proceedings in Ukrainian law. So you're able to do a rehabilitation proceeding first. That you're trying to just get rid of your debts, but still staying in business. But if it doesn't work, because there are different reasons why this might be, your company is going into liquidation.
That's basically it.
Closing down.
Okay. There are various uncertainties that remain about the various possible gaps between the proposed legislation and the existing legislation. And those are better definition of criminal liability and role of law enforcement in cases of international bankruptcy, then transparency and adequacy of sales or electronic sales, greater efficiency of court procedures, better regulation and oversight, and stronger profession of bankruptcy trustees. What else?
That's more or less the main points.
More or less, that's it.
Yeah, more or less that's it. Because
okay. Well, I'm assuming that coming up with the new code, the Ukrainian officials have gathered and collected information beforehand. They have obviously collected it, taken into account experience of other countries. You come from Germany. How does the procedure for for bankruptcy filing happens, and what's happening in Germany when an institution tries to file for bankruptcy?
In Germany, the institution has to file with also lots of documents. They are more or less similar to the ones you need in Ukraine. And then you also get an insolvency administrator. It's named a little bit different in Germany, appointed as well by the court. And the court decides who's going to be there. In bigger companies, the creditors may have some right to choose who's going to be appointed, but the court still has the last wording on it. So the court is still the person, or the judge within the court is just the person appointing the insolvency administrator. And then we have a so-called preliminary insolvency proceeding that's up to 3 months, where the insolvency administrator is just checking if there is a reason for insolvency, if there's a real reason for insolvency, or this is just like a fake insolvency.
Right, that's what I wanted to ask. What about the cases of fake insolvency, fake bankruptcy? How do we deal with that? How do the courts and the trustees and all of the figures that are taking part in this process, how do they actually realize if it is a fake procedure, if it is a fake claim for bankruptcy, or is it a truthful one?
Usually it all depends on the claim of the person who filed for insolvency. If there's a debtor filing. So if there's a debtor filing for a reason that never existed, you definitely know it by viewing through all the papers. But sometimes there are small claims, maybe from workers who have been not paid for the last months, and they're trying to file for insolvency. That you see, okay, that's not a big issue for the company itself to pay an outstanding workers' compensation, but the workers are only a small amount of the money that's really owed by the company. So then they start, okay, we start thinking about it, and we see, once we looked inside, it's much bigger than we saw at first.
Is there a penalty for the companies who try to file for fake bankruptcy?
Yes and no, because they're trying to do a betrayal, but there's not a criminal liability in that case, or not a strong one, because the stronger version in German law is the civil compensation, because they have to pay all the court fees, they have to pay the administrator that was working, they have to pay, especially if it's a fake thing, they have to pay the damage claims later on that may arise, and they might become very huge. Okay.
Well, thank you so much for coming here and clarifying the whole situation with the new code for us and our audience.
You're welcome. Thanks.
That was Arne Engels. He's an international expert of the EU Project Pravo-Justice, attorney at law, specialist in restructuring and insolvency cases from Germany. Thank you so much for watching Head to Head. Stay tuned with UATV.